Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're charged and arrested for OUI in Concord District Court and it's your second offense. So we group second offenses into two types of cases. One where your first offense is within 10 years, the other when it's outside of 10 years. So if your two offenses are outside of 10 years, you got a little more flexibility. There's more options in terms of how you can resolve the case and get back on the road. So when you refuse a breath test on your second offense, you're looking at a 3-year license loss. Now, theoretically, you can appeal to the RMV. I don't recommend doing that because the RMV is going to take out an immediate threat suspension, and those appeals are almost always denied. So to avoid this 3-year suspension, you need to win your case and be found not guilty after trial. If your two OUI offenses are within 10 years, you need the not guilty, otherwise you're not getting back on the road. There's no hardship on a refusal when the two offenses are within 10 years. If you're outside of 10 years, there's this disposition or resolution in your case called the Cahill, where you can get treated as a first offender and you can get back on the road with an interlock device. So if after trial, the judge gives you the standard first offender resolution, even though it's a second offense, you can get back on the road with an interlock device, or it can be on a plea. Usually it'd be a guilty probation 24D. That's what's called the Cahill resolution. You treat a second offense as if it's a first offense. Now you're going to have the interlock in your car for 5 years if you refused a breathalyzer, a hardship for 3 years plus 45 days, and the interlock for another 2 years. How soon can you get back on the road? It depends on the facts of the case. If you have to go to the Board of Appeals, it's probably going to take you 4 to 6 months to get that hardship. If this is a case where the registry would reinstate or allow a hardship, meaning you don't have much of a driving record, the facts of the case weren't that egregious, then you could probably get back on the road within a month. So that's what's called the Cahill resolution. Now, if you took a breathalyzer and went over 0.08, it's easier to get back on the road even if your offenses are within 10 years. So if your offense is within 10 years, you got the 30-day penalty for failing the breathalyzer. And then if you were convicted of the OUI or resolved the case, you have two additional years. The key thing, though, is the board has the ability to give you an early hardship on a second offense. You're going to have to do a lot of alcohol treatment counseling to get this, but you might be able to get back on the road within 6 months to a year because there's no refusal suspension. Same thing with you took a breathalyzer. If it's a Cahill resolution, you have the same ability to get treated as a first offender and get back on the road quicker with an interlock device for 2 years if you took a breath test and failed. So keep this in mind that you need to know how close in time your two OUI offenses are, and then that will determine how soon you can get back on the road. It's really important to try to fight these cases and win an OUI case because it's hard to prove an OUI beyond a reasonable doubt. So it's easy to get arrested, difficult to be convicted. It takes a lot of evidence for the government to convict somebody. They got to prove the case beyond a reasonable doubt. That means the highest degree of certainty in the matter of human affairs. So it's a high standard. Just because you were stopped and arrested doesn't mean the government can make to satisfy the level of proof to beyond the reasonable doubt. So, for example, field sobriety tests that you might have taken on the side of the road, like a one-leg stand, walk and turn, these often can be unreliable. There's a lot of reasons somebody can't balance on one leg or walk a straight line other than alcohol. Often the instructions are confusing. You're doing the test on the side of the road. You might have had a medical condition that makes it difficult for you to do a field test. So when there's no breathalyzer, these cases can be difficult to prove, especially when there's no serious or egregious driving. If you took a breath test, know that there are ways to get the breathalyzer excluded from evidence. So you can still fight the case despite there being a breath test in the case. So don't assume you need to plead the case out just because you took a breath test and it was over 0.08. There is one other option too. If you have a second offense OUI and your first offense is between 2012 and 2019, there might be a motion to reopen that first OUI to make it your current OUI a second offense. I've done this many times for clients to help them get back on the road quicker. That's one way if you have a second offense within 10 years, where if you can reopen that first offense, that would knock down your 3-year suspension to 180 days. So as you can see, there's a lot of moving parts in terms of the license. Make sure you understand the license consequences. Ask the attorney about that. Make sure you feel comfortable that you understand all the ins and outs of the registry. Because the registry consequences are determined. The registry doesn't act randomly, whatever. The registry rules are very clear, and there is some discretion in registry decisions, but in terms of second offenses, depending on how it's resolved, you can expect the suspension required by law. So your first court date, generally, just like on your first offense, you'll enter not guilty, get a further date for pretrial. If it's an egregious case, you might be looking at a condition of no alcohol, but generally second offenders will get released on their promise to appear. In court, I generally would recommend doing alcohol treatment to assist us with the registry, getting your license back, and leniency from the judge and consideration from the DA. So make sure you get treatment. Not only do you want to do it for the case, but more importantly, you probably want to do it for yourself. You can be found not guilty and still deal with a problem. If you got arrested for the second time, there might be something wrong. It could be that those were both freak incidences, that you shouldn't have been stopped. But a lot of times there is some problem. It might not be that you were guilty or that you even violated the law, but do yourself a favor and recognize if you need help that it's not going to be used against you. Some people think, well, if I do alcohol treatment, they're going to think I'm under the influence or I have a problem. The court generally thinks if someone's there's a problem, and they appreciate it when people are proactive to get help and to make their life situation better and recognize the value of treatment. So call, text anytime, 781-686-5924. My passion is helping people charged with OUI offenses get their license back, get back to work, and get their lives back, and I can help you as I help many people over the years.